is Pat's intro. G'day, Pat. How you going, mate?
Good afternoon, everybody. G'day, Mike.
Pat, I've invited you in today because we've got to do some basics for the loss adjusting program. And although they're basic, they're very, very important. And a lot of people get confused about it. They get conflicting information on it. And most often they're pretty straightforward. Now, the two things I'm going to ask you about today, Pat, basically a definition of fraud and hearsay. So are you happy to run with that?
Yeah, that's fine. Yep.
No worries. Ladies and gentlemen, for the loss adjusting people in lockdown in Melbourne, here's Pat Flynn with the definition of fraud in a minute and hearsay first, I think.
Yeah, I'll deal with hearsay first. When you interview people and take statements from them, one of the most common mistakes is investigators tend to sometimes inadvertently, but they put hearsay evidence in statements. Now, hearsay, what's hearsay? Hearsay evidence is essentially what the word itself says. You've heard someone say something and you've repeated it. Now, in criminal trials, hearsay is generally inadmissible. The reason why it's inadmissible is how can I, if I've got my statement and I've got some hearsay evidence in there about what Mike Evans said or someone else said, how can I be cross-examined on what was actually said? The person who spoke the words needs to be examined in court and tested in court in regards to what they say. So we have an adversary system whereby any evidence that's led in a trial by either side, the other side has the right to test and examine that evidence and challenge it to make sure it's correct. In criminal trials, there are some general exceptions. There's three most common ones. One is, which everybody's probably heard of, a dying declaration or a deathbed confession. Sometimes you hear them called as that, but it's a dying declaration. The presumption at law is there if someone is on their last breaths on their dying bed, they're less likely to lie at that point in their life than any other time in their life. There's another exception whereby it's called the first or most recent complaint in a sexual crime. So where a victim tells someone else that they've been raped, that is hearsay evidence, but it's able to be given by the person it's told to, and that's an exception to the hearsay rule. The anomaly with that is it doesn't prove who did the raping. It proves that the event took place. So that's why sometimes, like your sex offenders that don't get prosecuted for a few years, the victim may not speak to anyone about the event that took place, and it might be that after suffering mental illnesses or depression or something like that after a couple of years or more, they may say to someone, the reason why I'm so upset and not well is because I was raped. Now, at that time, the person who is told that, they can give that evidence in court. Now, the third exception to the hearsay rule is a confession. So when someone tells you that they've done something, that confession can be given in court as an exception to the hearsay rule. You, as an investigator, weren't there when the offence took place or the event happened, so you can give that. There is a few conditions in regards to that. The person who gives you that information and makes that confession they must know that if they do tell you that, and they're aware that you warn them that if you do say something to me, I can give this in court. They need to know that they don't have to self-incriminate. It's the judge's rules which has led to why we have a caution now. You're not obliged to say or do anything, etc. So the person must know that they don't have to self-incriminate themselves, and also they should understand the consequences if they do. Now, the confession is an exception to the hearsay rule, and something that a lot of investigators don't do now, which was something that was done many years ago, and how I was first taught, was when you did a record of interview or you did an interview with someone who confessed to doing something, that's an exception to the hearsay rule. However, at the end of the interview, if you give that person you're interviewing a piece of paper and a pen, and you get them to write that down and make a statement about what they've confessed to, that then becomes stronger evidence because it's an actual statement made by the person who's made the confession. So rather than being an exception to the hearsay rule, it is first-hand evidence from that person, from that witness. So that's the reason why hearsay is generally inadmissible. Now, in the private sector, I've had occasions where solicitors have varying views in regards to hearsay. So criminal trials, generally inadmissible. There are certain occasions in civil matters where hearsay evidence can be given. It's generally narrowed down to first-hand documentary hearsay, such as statements and things like that, that can be tendered without having the person there to give evidence about the making of the statement. So the other thing that you need to understand too is also that very few matters ever go to court in the private sector in a civil matter. It's usually only 1 or 2 out of 100. So most of the matters that are dealt with from a civil point of view, they're settled out of court. They're settled by sitting around a conference table, having a settlement conference, mediations, things like that, where they come to an agreement to settle. So in the correct way that you define hearsay, a court will determine what's hearsay and what's not. Whereas around a conference table, that is not a court, so therefore sometimes you can introduce hearsay evidence in your statements. All of your major clients, like your work cover authorities, people like that, they generally don't want hearsay in any of the statements to contaminate them. They want hearsay excluded from statements. However, sometimes the hearsay evidence can be relevant and it can put some perspective on what was said by the person giving the hearsay evidence. I've had solicitors say to me, I don't want hearsay in the statements. And then I've had other solicitors say, I'd rather see the hearsay in the statement. It gives me something else to use when we're negotiating. So it really comes down to your client, what your client service level agreement is and what your client wants. Generally, though, keep hearsay evidence out of your statements. If you have a piece of evidence like hearsay evidence that you want to include while you're interviewing the person, there's nothing wrong with finishing your main statement, finishing that off, signing it off, do the jurat at the bottom, you both sign, the witness signs, then you sign after the jurat, and immediately after that, start a new statement. Just start a new statement and lead it off in words such as, I have previously made a statement in relation to this matter at the time and date that it was just done before. In addition to the contents of that statement, I wish to add the following, and then put in whatever the hearsay evidence is, whether it's only one or two paragraphs or a few sentences. Then when you send that in to your client, they can decide whether they're going to use it or not. If you're already out and you've travelled somewhere to interview someone, the extra couple of minutes to do another little statement, print it out and get them to sign it, that's inconsequential, and your client then can make the judgment call in regards to whether they're going to use that or not. Generally, when you have hearsay evidence, that will be someone has told your witness something. So the process from there is go and find that person that told your witness the words that they spoke, which is hearsay evidence, and go and interview them and get a statement from them, and then it becomes first-hand witness evidence. That's pretty much covered everything, I think, in regards to hearsay evidence. I'll go on and I'll just have a talk about fraud now, if you like, Mike.
Yeah, just to clarify, Pat, so it's hearsay if they didn't experience it with one of their five senses.
Five senses, yep.
So if they personally, the person giving you the statement, didn't hear it, see it, touch it, smell it, and I don't recommend it, taste it, that's the hearsay test, is it wasn't experienced with those five senses. Now, you don't go, that's hearsay, don't. You ask the person, like Pat said, in a separate statement, or just stop taking the statement and say, well, who's that person? What have they got to do with this? You know, who's Freddie that was walking past and mentioned this or told you that? And then you can go and get a statement off them if that's authorised later. So covered the subject, Pat.
And look, it might be something along the lines of, you may be doing a work cover investigation for a workplace injury. And during the course of doing that interview with, say, a claimant, they may tell you that what's happened in this workplace is something that's happened in another workplace that I worked at previously. Now, what's happened previously has no relevance on the claim that you're actually investigating in the separate workplace, but it may be something that's important, such as if it's a similar thing that's happened, such as bullying and harassment or whatever, and it's a stress claim or whatever like that, it may not be the work cover claim that you're investigating. That may not be the primary cause of the injury. It might be an injury that's been caused in a previous workplace, and it's an aggravation of a previous illness or injury. So that's where it can become relevant, but it's still hearsay evidence. Excuse me. So, yeah.
Just to reiterate, we get very serious claims. I have taken statements from 3 people that died the next day. Now, they weren't giving me dying declarations, but if you've got someone with asbestosis or ciliosis like you're going to have today, could be smoke inhalation, in complications with other things, and the matter that you're interviewing, their families relying on that interview. Now, they're not really giving you a dying declaration, but we must be prepared as investigators to be in situations that are highly emotional, where we have to be professional and follow right through. We're not there to deny anybody's claim. We're there to find that person's version of events, and if they tell us what it is and we report it as they've told us, it's confirmed by the witnesses, then those 3, I know the ones that I did, they had quite successful outcomes for the beneficiaries in relation to that. So we've got to be ready for that. Pat, I'm going to let you go on with fraud.
Okay. What is fraud? Now, I've got a couple of little definitions that I jotted down before we started here today. The ACCC, they use a definition of fraud, which is dishonestly obtaining a benefit or financial advantage, or causing a loss by deception or other means. So that's what the ACCC defines fraud as. The Association of Certified Fraud Examiners, their definition of fraud is a knowing misrepresentation of the truth or concealment of a material fact to induce another to act to his or her detriment. The Victoria Police have a fairly simplified version of what fraud is, using deceit to obtain an advantage, whether it's property or financial, or to avoid an obligation. So it really comes down to knowingly misrepresenting, being dishonest by a trick or deceit, something like that. Now, in respect to loss adjusters, pretty much all you're dealing with is insurance fraud. Now, from an insurance fraud point of view, it's a deliberately dishonest act. And that's generally what you're looking at, a deliberately dishonest act. And it can be something that's opportunistic, such as the padding or exaggeration of an otherwise legitimate claim. So it might be adding a few more things to the shopping list when they put their statement of items that are, or their schedule of items that have been stolen from the house burglary. As opposed to opportunistic, it might be premeditated. It might be a deliberate arson where someone has set fire to property to destroy it to claim an insurance claim on it. It might be theft. It might be staged incidents involving the deliberate fabrication of the circumstances of the claim. The other thing it can be too, from a loss adjuster's point of view, it can be fraudulent non-disclosure. So it might be a misrepresentation of the facts material to the insurance policy, such as a failure to disclose a criminal conviction or deliberately giving false or misleading information in support of a claim so that they can, like the insured person can obtain a benefit or a financial advantage. So everything that comes down to what is fraud is using deceit. It's usually deliberate, it's usually dishonest, and you're using some trick or deceit to actually accomplish your outcome. It's fairly common, the opportunistic padding of claims and things like that. You'll find that a lot, and that's why you have to ask those next level down questions, which I discussed the other day. You've got to ask questions to satisfy yourself. Did they in fact own that item that they've claimed to have been stolen? So it can also be, for a benefit or financial advantage in things such as putting in a false resume where you say you've got qualifications that you don't have, or you've got experience that you haven't had. It may be things like that. So if you're going to put a resume in to get a job and you've lied on it, it can be the outcome's going to be getting a financial advantage by getting a job. So it can be things as simple as that. But generally it's for insurance claims when you're a loss adjuster.
We had the case of the person who became senior manager in Myer in Melbourne a few years back.
Yeah.
About his qualifications, and they found out about it. They sacked him and they charged him with fraud.
Yeah.
Now, what would have happened if he hadn't got the job, Pat?
Well, that's right. If he hadn't have lied, he wouldn't have got the job. So, and he had, I think he had about 2 or 3 or 4 years or something of that job's wages, which he got because he lied. So, yeah.
And someone else who was qualified missed out. So,
yeah.
If you get the job and you lied, yes, that's fraud. If you don't get the job, well, you didn't gain any benefits.
Yeah.
These things will be argued by solicitors and barristers and that sort of thing. But in our case, we're not always dealing with sophisticated Mr. Bigs. And insurance companies do have leeway to allow a small exaggeration sometimes in fires and burglaries and floods. It's not well known, but they will allow a little bit of leeway. If they've had a customer for 35 years, that's just natural with any business. But if they've had a customer for 24 hours and suddenly a big claim comes in, they're really going to go into detail. And that was the first factual investigation I ever got, was the policy was taken out yesterday. The claim came through from an incident overnight. And the next day I'm interviewing the manager of one of the most senior car manufacturers in Australia on my first job in relation to a fraud. Now, it wasn't, but on the alert system, the policy inception less than 24 hours old, that came up as an alert and it just followed its process. So with the frauds that we do, you don't know that it's fraud. No one will tell you in your instructions generally it's fraud. They do have alerts for frauds in various cases, such as stolen motor vehicles recovered burnt out. There is an indicator there that someone had time to set fire to that vehicle and destroy any evidence within it. How hard is it to burn a vehicle, Pat?
Pretty easy, pretty easy. A favourite to start a fire in a car is get a bag of potato chips, and you light the potato chips and put it under the seat, and away she goes. Another type of fraud that we get a lot in Queensland here are hail damage to cars. That's a quite common one here. And what a lot of people don't realise is hail won't damage the paint on a car, whereas if you get say a golf ball and put it in a sock and you swing it round and you make dents on your car, or you put a ball peen hammer inside a sock and you make dents on your car to make it look like it's got hail damage so you can get a repaint. The good assessors will actually look at all of those dents under a jeweler's loop, and they'll actually put stickers on them to say, well, that's a good one, that's a real one, no, that's been fabricated. So yeah, it can be anything like that. So,
and people will do that because they'll have a policy that says if X percentage of your vehicle is destroyed by hail, you'll get a new vehicle. So they wrap that ball hammer up in a tea towel and give her a few extra whacks to get the percentage up. And when it goes to the assessment centre, the people just x-ray that paint and they know straight away. So then you don't have to do that as a loss adjuster. They'll be appointed separately from you, and it may come up later or it may come up before, but that's the world we operate in. So there's technology to support the decisions they make, along with our time and event line, which was our first one earlier this week, our witness statements, all that sort of thing that we've put together. Pat, thank you for coming in today. I really appreciate that, mate. If you stick around, I'll have a chat to you afterwards. I've just got to show...
I hope that's helped a bit. So, yeah.
I've just got to show one quick video about fraud.
Goodbye, everybody.
Back in the year 2000, I had to attend WorkSafe in Queensland's head office. They were going through a tender process to appoint a panel of investigators and loss adjusters to their panel for workers' compensation claims. They'd just discovered some fraud in the actual process of investigating. Now, the person who did it was a qualified, chartered loss adjuster. He was an alcoholic, he was a gambler, and they put him under surveillance, and he was quite frequently blowing large sums of money into poker machines around where he lived. Now, the issue with that, you can gamble, that's fine. You can go and you can drink, but to fund what he was doing, he was filling out his timesheets to say he interviewed someone for 4 hours face to face. He travelled for 3 hours to get there. He then travelled back, and he put in a timesheet saying that back in the day, $80 an hour as a loss adjusting assignment. Now, when they checked with the people he interviewed, they said, oh, yeah, I spoke to that guy. And they said, did you give him a statement? They said, yeah, over the phone. And he posted it to me and I posted it back. How long did it take? Oh, about 10 minutes. So he was charging 3 hours for 10 minutes. He wasn't driving, he was claiming the travel time, the kilometres, all that sort of thing. And he'd done it on literally hundreds of cases. Now, he wasn't in a good state of mind, but they didn't have any checks or risk management back then. They were, you know, nice, honest government department that believed all their suppliers were qualified and nice, honest people. You are going to come across fraud. I do not want you to be obsessed about it. None of us are master investigators. Don't let anyone ever tell you that. And we don't go looking at one little thing and think, oh, that we can make that into this and blah, blah, blah. There's a final part of this week from a very experienced investigator that Pat Flynn knew very well, may he rest in peace. Let's have a look at what he advises in relation to making things out of facts and facts out of things. Peter Spence is one of our instructors. He says there's no Sherlock Holmes in the world. Investigation is 1% inspiration, 99% perspiration. To catch people who do fraud, you must think like them. Think and keep an open mind. Sometimes you might get tunnel vision, and he admits it. He's done it himself. I've done it myself. You don't make things out of one fact. You don't make 5 facts out of one thing. You must convince the person that you're talking to it's in their interest to help you. In this work, you are going to learn 3 things every day. That's what happens. One day, you're interviewing someone about an accident at a dairy. The next day, you're interviewing someone about an accident in a manufacturing plant. And that afternoon, you're talking to someone about a slip, trip and fall in a shopping centre. We're learning different things every day. All of us, we get to know a range of different things, but each case falls on its facts. I'll end it there. Thanks for coming in, Pat. We'll see you next week, people. I'm Mike Evans from the Australian Security Academy.
Good afternoon, everybody.
작전 종료. 전원 복귀할 것.